Hi, this is Lee Phillips. I'm an attorney. I want to talk about trusts with you. I've worked with trusts for a long time, and they're actually neat tools that a lawyer has available to him to help you and your family in many different circumstances. The question is, what is a trust? Let's do the basics. A trust has three players. There's the guy who sets it up, and he's called the grantor, the trustor, the settlor. I mean, all three names, they're almost used interchangeably. In fact, you'll see trusts, and part of the way through they call the guy the grantor, and part of the way through they call him the trustor, and it goes on down. Then you've got the trustee. That's the guy who manages the property that's in the trust. He manages the property for the third party, the beneficiary. And you can obviously have more than one beneficiary, but you've got the guy that sets it up, the manager, the trustee, and then the beneficiaries, the guy that, or guys or girls, they get the benefit from the trust. So you've got three players. The trustee is under what we call a fiduciary duty. It's his duty to take care of the property in the trust to the benefit of the beneficiaries. And actually the fiduciary duty is a very well-defined duty within the law. And if you actually understood what the fiduciary duty was, nobody would ever act as a trustee. It just ain't going to happen, because it's an extremely high bar that this individual has to make or has to meet. Now, you could be the grantor, the guy who sets it up. You could be the trustee, the guy who trustees it, and you could be the beneficiary, the guy that gets the benefit. So you can hold all three positions, you can hold one position, you can hold two positions, and depending upon which positions you hold, you will get a different asset protection aspect to this trust, and you will get a different tax aspect to the trust. The trust is actually an old concept. You do trusts all the time. You don't need to have a writing, a trust document, in order to make a trust. All I have to do is say, hey buddy, I'm going to the bathroom. Would you watch my luggage for me? I'll be back in a minute. You have now created a verbal trust. You're the guy who gave up the property. There's another guy who's taking care of it, and you're going to be the beneficiary when you get back. That's a trust. The written trusts are actually several thousand years old, so this concept of writing it down and having it be more formal goes back a long time. We have lots of different types of trusts, but there are two primary divisions. One is revocable. I can revoke it. I'm the grantor. I get to do whatever I want with it. If I want the property back, I can get it back. And there's an irrevocable trust. Can't revoke it. It's gone. Property's not mine anymore. It's the trust's for the benefit of the beneficiaries. So revocable and irrevocable. And the question always is, okay, do we have a revocable trust or do we have an irrevocable trust? And there again, they have very different asset protection and tax aspects to them. The tax aspects are actually twofold. You've got income tax and you've got estate tax. And a lot of the trusts have traditionally been used to avoid the estate tax, to manage somebody's property after they die, and hopefully to get a good tax break in the estate tax laws. Well, wait a minute. Why do we have trusts that get breaks in the estate tax area, or breaks in the income tax area, or provide asset protection? And I mean, we got dozens of different types of trusts. There are children's trusts, there's charitable trusts, there's living revocable trusts, there's land trusts, insurance trusts, all kinds of different trusts, and there's a set of laws for each one of these different types of trusts. The reason is Congress or the insurance lobby or somebody wants this law written so that if I write a trust and it meets these criteria, then I get this result when I get sued, or I get this result when I pay my income taxes, or when I die, I don't have to go through probate. Whatever the result is, then we've written the law specifically so that if we write the trust this way, we get this result. So you need a written trust, but you don't have to have it in writing. But if you're going to get the tax breaks and you're going to get the asset protection and stuff, it does need to be in writing. So we write trusts. The lawyers write lots of trusts. You can write a trust. In fact, we've got another YouTube on whether you should use the lawyer or whether you should write your own trust. That's for another story. But right now, just understand it's a simple concept, and we have different laws that define different types of trusts. Charitable trust, I can give up my property today. It goes to the charity when I die. It's not mine. I get a tax deduction for it today because I gave it away to the charity. But if it's a rental property, I get to have the rent for the rest of my life, even though I've given it away. So that's one law, and it defines a specific purpose of a trust. Just understand there are different types of trusts. In fact, it even goes deeper than that, because if I'm doing a simple, let's say, living revocable trust, it's a probate avoidance tool, and we've got lots of YouTubes on that. But if I have a living revocable trust, it could be called a loving trust, a family trust. The lawyers make up specific names so that you have to come to me. I'm the lawyer that's got the loving trust or whatever it is. No, they're all just revocable living trusts used for estate planning by a different name. So you'll have different names for the same trust, and you actually have different trusts that form different functions. So concept trust, very easy, but it's a very powerful tool for estate taxes, income taxes, asset protection, estate planning, all sorts of stuff. Trusts are neat, and we're going to explore them through a series of probably almost 100 YouTubes for you, because there are lots of moving parts and you need to understand them.